We're now going to move into chapter 11 and talk about written contracts. Now, obviously there are certain contracts that don't have to be in writing, but let's just face it. As a general rule, you probably want all contracts to be in writing. I mean, let's face it. Shaking another man's hand doesn't really mean as much as it used to. So let me present the question. Why get something in writing? To prove something? To show the courts what the agreement was? Just so that later on you're not having two parties saying, oh, you said this, you said that. It's all good reasons. Now, the statute of frauds was actually created to express certain contracts that must be in writing, and it's very easy. There's an acronym for it. It's called MyLegs. Okay? Now, MyLegs, M-Y-L-E-G-S. Marriage. Contracts in anticipation of marriage need to be in writing. Okay? And prenuptials. That sort of thing. Contracts saying, hey, you can marry my daughter or something like that, even though those are pretty much contrary to public policy. Why? Year. Contracts that cannot be performed within a year must be in writing. Okay? I promise to babysit your dogs next weekend. Does that have to be in writing? No. Okay? I promise to babysit your dogs for the next 68 weeks. That has to be in writing. There is no way that contract can be performed in less than a year. Okay? Legs. L. Land. Contracts dealing with real estate must be in writing. Okay? E. Estates with wills and trusts. Most contracts dealing with wills, trusts, and estates need to be in writing. G. Goods over $500. This comes out of the Uniform Commercial Code. If two merchants are purchasing and selling items and they're worth more than $500, those contracts must be in writing. And finally, a surety. This is basically answering for the debt of another. I, Mike Childs, hereby agree to answer for the debts of you, Bob. Okay, it's not enough for that to be spoken. That needs to be in writing. I'm answering for the debts of another. Now, what do we actually need to constitute a writing? Well, it can be anything. It can be this formal, drawn-up contract. Here, the party, the first part, in consideration of $10, do hereby agree to the party, the second part, to do the following contract. Boring. You can also do a note or memorandum. Okay? I reference our conversation of earlier today, and it is my understanding that these are the terms of the contract we've set forth. Easy, right? Only thing that needs to really be in the contract that constitutes the writing is the material terms. What are we contracting for? Are we contracting for 500 widgets at $100 a widget? Or are we contracting for a car? Car probably isn't good enough. You'd probably need something like, we're contracting for a 1969 Chevy Camaro. That'd be a little bit more appropriate. Now, parole evidence is an interesting thing. Remember when I mentioned, you want to have a contract in writing so that later on you won't say, oh, well, he said this, they said that. That's parole evidence, right? Basically, parole evidence is oral evidence that they want to bring in court. Look at the parole evidence rule. Complete written contract may not be modified by oral testimony unless evidence of fraud, accident, or mistake. So you have a contract written in writing. That constitutes the entire agreement. So testimony, oh, you said this. Oh, you said that. This was supposed to be this. This was supposed to be that. That is inadmissible in a court of law. Okay? Unless it's to explain. Okay? What did we mean by this terminology? That's okay. But bringing in evidence that there were other terms to the contract are inadmissible in a court of law because of the parole evidence rule. Chapter 11 is a very easy chapter. Just remember the acronym MyLegs.